Hello and welcome to the Herrington Carmichael Employment Law Update for April 2019. I'm Alistair MacArthur, I'm the head of the employment team with Herrington Carmichael, and as always I've got the 4 key things for you in the last month in the world of employment law. So let's start with the issues of suspension and the case involving the London Borough of Lambeth this month. This case involved a teacher who was overly aggressive with a child, and that resulted in their suspension from their employment. They tried to argue that the suspension wasn't an appropriate response to the actions, and as a consequence they pursued proceedings through the High Court and the Court of Appeal. And in these proceedings, what the court said was that ultimately an employer must have a reasonable and proper cause for suspending an employee. Now, if you've ever dealt with suspensions of employees, you will know that this is often a knee-jerk reaction to a situation, and we have to move away from that knee-jerk reaction now and to look very clearly at why employees are being suspended and make sure that it is an appropriate response to the situation. If you're looking at disciplining and suspending, please come and take some advice. Moving on, next case is the City of Oxford Bus Company and Harvey. This case relates to a discrimination claim on grounds of religion or belief, and the issue of the provision, criteria or practice that the bus company was applying. In this case, the individual was a Seventh-day Adventist and wanted to avoid working on his Sabbath. He was therefore accommodated on a temporary rather than permanent basis, and argued that the fact that it was a temporary rather than permanent basis gave rise to a PCP, and that was discriminatory. And in this situation, what was held was effectively the PCP or provision, criterion and practice has to be assessed in the context of the employer's business rather than in relation to the individual. What this means is that effectively a broader, more objective look will be considered in relation to the PCP, and specifically that means that it can be harder for individuals to substantiate their claims where they are the individual or the person who is most affected. It's a situation to watch, and it's one to treat very carefully, and again a situation to take some very careful legal advice. Next, another disability discrimination claim which is in relation to I-Force and Wood. In this case, the individual concerned believed and mistakenly believed that they were going to suffer ill health or a disadvantage by working in a particular space or a particular environment, and as a consequence they pursued a claim. However, their belief of the unfavourable treatment was mistaken. They weren't actually going to suffer the disadvantage or the ill health they thought they were going to suffer. And as a consequence, the court held that actually no, you couldn't have discrimination on the basis of a mistaken belief. There was no unfavourable treatment in that scenario. Again, it's a very narrow band, because where, particularly with disability discrimination claims, and where medical advice is required or individuals are asserting particular rights as a consequence of their disability, it can be confusing. This is a situation again where clear advice is required and where you should be taking proper medical investigations in relation to the individual's condition. Finally, the case of Astrip and Dogra, which relates to Employment Tribunal and Employment Appeal Tribunal time limits. Once again, as it comes as no surprise to many of you, that cases are dismissed where the time limits are not properly complied with. If you have time limits and you are applying with court procedures or tribunal or appeal tribunal procedures with time limits, make sure you are complying with them, or else cases or responses will not proceed. That's it from me this month. I wish you a very good rest of the April period, and I look forward to speaking to you again in May. Thank you.